Jurisprudence and its kinds. Jurisprudence is like the thoughtful explorer of laws. It's not about just knowing what the rules are, but understanding why we have them and how they fit into our lives. It's like peeking into the history, philosophy, and reasons behind laws. Jurisprudence helps us see how laws connect with things like fairness, ethics, and society. Just like a detective, it studies how laws change over time and how they affect people. So, think of it as the curious mind that uncovers the stories and meanings behind the rules that help us live together peacefully. Kinds of jurisprudence. Jurisprudence, the study of laws, philosophy, and principles, encompasses several kinds that delve into different aspects of legal thought and analysis. Here are some of the main kinds of jurisprudence in detail. 1. Analytical jurisprudence. 2. Historical jurisprudence. 3. Ethical jurisprudence. 4. Philosophical jurisprudence. 5. Normative jurisprudence. 6. Sociological jurisprudence. 7. Comparative jurisprudence. 8. Critical jurisprudence. Analytical jurisprudence. Analytical jurisprudence focuses on precedents and understanding the importance of precedents. It's like taking a puzzle apart to figure out how all the pieces fit together. This method demonstrates clarity, logic, and structure. Important questions include: what is law, how is justice given to law, and how do laws affect each other? Legal positivism is a theory that argues that law creates problems in this field. There is no necessary connection between law and morality. Analytical jurisprudence attempts to interpret the nature of law in a way that transcends culture and historical context. Historical jurisprudence. Historical jurisprudence is like a journey through time, exploring how law has developed over the centuries. It explores the development of law, the influence of past societies, and the historical events that shape the law. This approach can provide insight into the law's history, development, and social impact by understanding the context in which the law was created. Historical jurisprudence shows the evolution of legal ideas and practices, helping us know that the law adapts to the changing needs of people. Ethical jurisprudence. Ethical jurisprudence refers to the moral compass of law. The question seems to be whether the law is not only legal but also moral. This branch deals with issues of justice, equality, and human rights. Moral law examines laws based on principles of justice and whether they promote human dignity. It asks whether laws can be considered good if they are unjust, and how laws should be changed to be more morally beneficial. This approach requires us to think about the basis of the justice of the law and its effects on people. Philosophical jurisprudence. Philosophical jurisprudence explores big questions about the purpose, meaning, and relationship of law to people. It seems to reflect the nature of the law. This approach examines concepts such as justice, law, authority, and legal reasoning. Philosophical law seeks to understand the nature of law and the role it plays in the creation of people and society. It touches on many philosophical issues, explores the ethical and metaphysical dimensions of law, and contributes to the discussion of what laws should be and how they affect our lives. Normative jurisprudence. Normative jurisprudence is the in-depth study of fairness and justice in law. Its purpose is not to explain what law is, but to determine what law should be. This law deals with issues of justice, law, and the relationship between law and morality. The study of how law is made and interpreted is the foundation of law. Sociological jurisprudence. Sociological jurisprudence examines the relationship between law and society. It determines how law affects the human body, relationships, and organizations. This organization demonstrates the role of law in regulating and creating the relationship. Legal law, which studies the interaction between law and society, refers to how laws are created and the society they govern. Comparative jurisprudence. Comparative jurisprudence deals with the study of different legal systems in different societies. This law attempts to identify similarities, differences, and patterns by comparing the laws, statutes, and regulations of different nations and countries. Comparative law helps us understand how legal systems solve similar problems and adapt to different contexts. Critical jurisprudence. Critical jurisprudence uses a critical lens to examine the power dynamics embedded in legal systems. It will take time to see how laws create inequality and support existing power structures. Scholars primarily study how race, gender, class, and other social factors influence the Constitution. This approach is to expose hidden injustice and promote social justice through legal reform. Scope of jurisprudence. The scope of jurisprudence is broad and covers various topics and areas of study around legal concepts, principles, and theories. Here we examine some scope of jurisprudence. Nature of law. Jurisprudence is the in-depth examination of the importance of law itself. It asks what the law is, its content, and the basic features that distinguish it from other laws or characteristics. This approach involves understanding the concept of legal validity, the role of law, and the ways in which law interacts with society. Legal systems and theories. Jurisprudence explores different legal systems around the world, including common law, civil law, religious law, and law. Analyzes the principles of these systems and the theories that guide their development and use. Sources of law. This section of jurisprudence examines the basis of the law. Examines legal law such as rules, procedures, statutes, and international regulations and their impact. Law and interpretation. Jurisprudence carefully examines the process and explanation of decision-making and interpretation. It seeks to understand how judges, lawyers, and scholars analyze and apply legal texts and principles to specific cases. Juridical concepts. Concepts like rights, obligations, duties, and liabilities are explored within the scope of jurisprudence. This involves understanding the nature of legal relationships and the consequences of legal actions. Justice and morality. Ethics and justice are central themes in jurisprudence. It investigates the moral and ethical foundations of law, addressing questions of fairness, equality, and the balance between individual rights and societal needs. Legal change and evolution. Jurisprudence studies the historical evolution of laws and legal systems, tracing how they adapt to changing societal, cultural, and technological landscapes. Interdisciplinary connections. Jurisprudence interfaces with various disciplines, including philosophy, sociology, psychology, economics, and political science, enriching its scope by incorporating insights from these fields. Comparative law. The scope extends to comparative legal studies, where different legal systems are analyzed, compared, and contrasted to understand similarities, differences, and trends. Legal philosophy. Jurisprudence engages in philosophical inquiries into the nature of law, exploring theories like natural law, legal positivism, legal realism, and more. Social impact of law. This aspect examines how laws influence and shape society. It analyzes the effects of legal decisions on individuals, communities, and broader social structures. Human rights and civil liberties. Jurisprudence explores the foundation and scope of human rights, civil liberties, and their protection within legal systems. Critical legal studies. This emerging field within jurisprudence questions the social and political implications of law, challenging traditional power structures and advocating for social justice.